We are live and recording.
Thank you very much. We're here for a motion hearing in 2019 P 1435, Commonwealth versus RIVERA. As you may or may not know, I tend to handle these single justice matters fairly informally, similar to a Superior Court hearing. There is no clock. You will each have an opportunity to speak. More than one opportunity to speak, I should have said. And I actually am going to ask the Commonwealth to speak first. But before I do that, I thought it'd be helpful for everyone to sort of hear what my current thinking is and what concerns me. Before I do even that, I wanted to thank the Commonwealth for providing the documents it did about an hour ago. I assume Mr. Campbell has them as well. He's shaking his head yes. They're helpful. I don't completely understand them, but I'm sure we can get into what they are. Let me turn then to right to the issues. In terms of the three prongs that Nash says we need to look at, I agree with Justice Wendlandt that the defendant has met the first prong. In fact, I think, in my view, that's fairly clear. So I'm happy to hear from the Commonwealth why it thinks otherwise, but I wanted to put that out there because the issue isn't, of course, what is the likelihood of success on the merits. And it's whether there is an issue worthy of appellate review. And the case law makes it fairly clear that that is a reasonably low bar. And if need be, we can get into why I think that there's at least one issue that meets that criterion, but I wanted to put my view out there. On the security issues, there are obviously some considerations on both sides. What I'm trying to grapple with, frankly, is the fact that the context of this case is quite similar to that of Nash in terms of the fact that it's sexual abuse of a minor that happened to be very close to the defendant, and the defendant had no priors and successfully was out on bail pre-trial and other similar factors. Similar to what happened to Nash, the single justice here relied in great part on, in her words, the serious and violent nature of the crime. And the SJC addressed this issue head on in Nash and concluded, at least in that case, that despite the abhorrent nature of the crime, there were not sufficient security issues presented to warrant keeping the defendant incarcerated pending his appeal. And it's important for us all to keep in mind that the SJC went out of its way to say that it decided Nash without consideration of the COVID factors. It went on to talk about the COVID issues, but the court made it clear that even without the COVID factors, it believed that the ordinary two-prong test had been satisfied. So I'm obviously very interested in hearing what the Commonwealth has to say about that. Now, turning quickly to the COVID factors, everything seemed fine at Gardner until about, I guess now 2.5 months ago, when things started to explode. And in fact, 2 inmates died in December. And the numbers in January are somewhat off the charts. They thankfully started to come down in February, seemingly fairly dramatically, so that the first week in February, there were, I think it was 10 active cases, but then they've gone back up, not as high as they were at the peak. But as of the most recent report, which was just filed by the Commonwealth, there are 58 active cases among the inmates at Gardner. That, in context, is a very high number and one of great concern. And it seems uncontested, at least it was at the earlier stage, that this defendant has some health issues that increase his risk, even though he's a relatively young man. Now, on the flip side, we have the vaccination effort, which is something that we haven't really grappled with yet as an appellate court system. And I obviously want to make sure that I understand the data that the Commonwealth has supplied, and obviously I'm going to have a conversation with defense counsel about this. But as I understand it, what we have is just the aggregate data from the DOC population as a whole. That looking behind the numbers, that aggregate data seems to suggest that about 2/3 of the incarcerated population has been vaccinated, and that the other third has refused. The numbers don't completely add up, but if I'm reading them correctly, they seem to say that, with perhaps a few exceptions, every inmate has been offered a first dose and has either accepted it or refused it. That said, we don't have, at least from the Commonwealth submittal, an answer to the question of whether this inmate has been offered the vaccine. I take it from the Commonwealth submittal of the health waiver form that the Commonwealth is suggesting that it may be inhibited from providing health data from the inmate without his permission, either because of HIPAA or something else. I'm frankly having a hard time wrapping my head around that issue, because it would seem to me that whether or not the Commonwealth offered to vaccinate the defendant is a fact within its knowledge that would not be barred from HIPAA, by HIPAA. In any event, defense counsel should be prepared for me to ask that very question of him in terms of whether or not he has received, or at least been offered, the vaccine. And then obviously there's the question of what we should do regarding the issue of potential refusals. Beyond that, there are some tricky factual questions about the efficacy of a single dose of the vaccine, and so forth. The Commonwealth's own website says that vaccine shots need a few weeks to be effective for the antibodies to build up. There's a lot of, if you will, chatter about the efficacy of a single dose of a 2-dose vaccine. But in my simple sua sponte searches, I have found nothing definitive on such issues, such that I could take judicial notice of this. To the contrary, I see a lot of cautions that there really haven't been scientific studies that demonstrate what the efficacy is of the first dose, and that it's, in any event, it's really important to get that second dose. So at a minimum, even if the defendant has been vaccinated, there's some question about whether or not he still faces some risk. So with that, let me turn it over to the Commonwealth first, and then we'll hear from Mr. Campbell.
Thank you, Your Honor. May it please the court. My name is Mary Nguyen on behalf of the Commonwealth. Your Honor, with respect to the first prong, the Commonwealth doesn't have anything further to indicate with respect to that prong. We do acknowledge that the SJC and Nash has recently indicated that it is not particularly onerous on the part of the defendant to make such a showing. And although we don't necessarily concede that issue, I don't have anything further beyond what the Commonwealth had previously filed in the trial court in its memorandum in opposition to the defendant's first motion for a stay of the sentence. And I did include that in my addendum. But turning to, if I may, turning to the third prong with respect to the COVID factors, addressing first, for Your Honor, the issues with respect to the vaccinations. In my conversations with an attorney from the legal division at the DOC, I can report that every DOC inmate who has requested a vaccine and who is not medically contraindicated has had at least their first dose. Specifically with respect to NCCI Gardner, the first round of COVID vaccinations, in particular, the vaccine Moderna was provided on January 18th and January 19th. And then additionally, in the commissioner's affidavit, which was also included in the Commonwealth's addendum to its response, there was also an indication that a round was given on January 25th as well. With respect to,
can I just stop you for a sec?
Sure.
I think there was a slight misstatement in what you said. I just want to tease at that. You said that they were given their first shot. Is it they were given the first shot or were offered the first shot?
So from the communication that I received on February 17th was that the first round of COVID-19 vaccinations for inmates was January 18th and January 19th. So my interpretation of that statement was that it was provided. The first round was provided.
No. I'm not questioning that.
Oh.
You said that every DOC inmate has had for whom it is not contraindicated has had the first dose. And what I'm saying is it that they've had the first dose or they were offered the first dose? Because a fair number have apparently refused it.
So I actually read to you verbatim the statement that was provided to me. So it has had at least their first dose. And then, so I don't know if that necessarily answers your question, but I did read that verbatim.
Well, it does appear to be contradicted by the documents you submitted, which seem to indicate that a fairly large number have declined the shot.
So with respect to that, I did receive a communication that if an inmate, and this is from an email from February 12th from that same attorney from DOC, and he indicated that if an inmate has not been vaccinated, it is because they refused or were not eligible. And then he pointed to the commissioner's affidavit, which would be paragraph 6, which talks about the individuals that were not currently eligible to receive the vaccine. So I point you to paragraph 6, and that indicates inmates and patients who are currently infected with COVID are within 10 days of a positive test result, or are symptomatic inmates who have allergies to vaccine ingredients, pregnant or nursing inmates, and inmates who have been positive and received plasma within 90 days. Earlier in the affidavit, which would be paragraph 2, the commissioner does indicate that inmates who may have been ineligible to receive the vaccine during the first round will have the opportunity to receive the vaccination once they become eligible. So from the communication that I received from DOC, not only are vaccines available, DOC is actively encouraging inmates to get vaccinated, including via an educational campaign. So to the extent that there are some members of the population that have not been vaccinated, I would suggest to Your Honor that those are individuals who have either declined or are those individuals who are not eligible because they are not medically contraindicated is the term that's used. And then with respect to specific information with respect to the defendant's vaccination information, I was unfortunately not able to receive that information specific to the defendant, and I did forward to Your Honor and to counsel the medical authorization that DOC sent to me. And my contact indicated if the defendant refuses to fill out that form, DOC was requesting a court order that specifically orders DOC to provide the defendant's vaccination information, and then to name which parties, either the court, defense counsel, or the prosecutor, who that information must be provided to by DOC. So unfortunately, I was not able to get specific information with respect to the defendant. I would defer to my brother in that regard as to information as it pertains to his client. Turning to the documentation that I received from the Special Master's Office and also from DOC, and I can also answer any questions with regard to what that information contains. But my reading of this week's numbers for NCCI Gardner, which would be the most recent would be the week encompassing February 11th to February 17th, that there are 7 confirmed COVID-19 cases in that time frame. And as
can I just interrupt you? When you say confirm, you're talking about new cases in that time frame, because as I read the form, there were 58 active cases.
That's how I read it, Your Honor. So there's 58 active cases in total, but as far as the weekly number from February 11th to February 17th, there are 7. But then if you turn to the daily numbers that I received from the DOC, you can actually see a breakdown by day. So just turning to that, Your Honor, and then turning to page 10 of the daily numbers. So it's entitled COVID-19 Spreadsheet for Inmate by Facility, dated February 16th, 2021. If you turn to page 10 of that PDF document, it will indicate the most recent data. And you can see that the number of positive cases, that being 7, references February 11th in particular. And then from February 12th through the 16th, each day there were no positive cases. So you can actually get more detailed daily information as to the numbers if you refer to the actual spreadsheet from the DOC, to give you a little bit more information from the Special Master's weekly numbers. So from what I gather from these documents, on February 11th, there were 7 new cases. And then from February 12th to February 16th, there has been no new cases, is my interpretation of the spreadsheet. Now, see if there's anything else with respect to vaccinations. Did Your Honor have any other questions with respect to vaccinations and or the documentation provided? Actually did want to comment on so the only thing I was able to receive from DOC was last week's, a report that was filed last week, which was entitled DOC Weekly Vaccination Report. And I read it the same way as Your Honor, is where it's a sort of an aggregate number. And from my communication with DOC, although DOC knows whether a given inmate has declined or gotten vaccinated, and knows the aggregate numbers, it does not actually compile facility by facility numbers, like in the case of positive COVID cases. So unfortunately, I don't have information in particular to NCCI Gardner. They do have the information with respect to the specific individual, whether or not he or she declined or received a vaccination, which unfortunately I was not able to receive with respect to this defendant.
And there is at least one document that it was not immediately apparent to me what it was, that include individual patient IDs and so forth.
I'm not sure which document Your Honor is referring to.
If you hang on, it is. I believe it's yes, COVID-19 data by facility inmate data. I'm sorry, it's not inmate specific, but it has a number of very confusing columns.
Can I point Your Honor to page 10 of that document? That's what I had been referring to when there's a daily breakdown. If you refer to page 10 of that document, you can see the daily numbers for NCCI Gardner in particular. After the second column, which would be after the date, it indicates NCCI Gardner positive cases.
Ah.
And that's on page 10. And then beside the positive cases, it shows you the active cases. So my reading of that is the positive indicates the new cases. And then the next column, active cases, would be the total number of active cases. So my reading is that on February 11th, that was the last time that they had received positive cases. And on that particular date, it was 7 positive cases. And it's been 0 from then on until February 16th.
And it looks like there was a third death in February.
I do see that as well. And it looks like that appears on February 15th as from my reading of the data, it would indicate, I believe, February 15th.
This, I have to confess that looking at this chart gives me some pause in that the data is very lumpy. For example, there are lots and lots of days where there's 0, and then on a single day on February 5th, suddenly 53 cases show up. And I mention this only because I'm not sure how much confidence to put in the fine-grained daily changes. In any event, the data is or are what they are, and I understand that your access to the data is somewhat limited. But why don't we turn to prong 2, which is
Certainly.
In some ways the most difficult one.
Thank you, Your Honor. With respect to prong 2, and I could be mistaken, but my memory, and I could be mistaken on the Nash case, is that the facts in particular, and I could be wrong, did not pertain to a child. I might have been an adult victim. I could be wrong about that, but that was my memory from reading the case. And I did read it last week, so I apologize for that. But that was my memory.
I may be wrong, but go ahead.
I could be wrong as well, but my memory, and I'll have to go back to the case. My memory was that I was an adult victim. So the Commonwealth's argument, and you could see it in my response as well, is that it is significant that it is the defendant stands convicted of a crime involving sexual abuse of a child. And like in Nash, it's individuals that have a close relationship. But in particular, in this case, it's a relationship of authority figure, that being the defendant, over someone young and vulnerable, a 13-year-old child. Certainly, those facts, which the jury convicted the defendant of, are significant when you are weighing the danger issue. So that's just one thing I wanted to note about Nash, which again, I can't speak confidently because I'd have to refer to the Nash case on the particulars with respect to the facts. But my memory was that it was an adult victim. So I do think that the fact that we have an aggravating factor here, that being a substantial age difference between the parties, the fact that there was a close relationship and one individual being an authority figure over the 13-year-old child is significant when you're considering the danger element. And then I'm just going to turn to.
I'm looking at Nash. It was indecent A and B on a person age 14 or older. The victim was the future sister-in-law. I'm not sure it ever names her age, but you obviously may be correct. Tell me why the adult versus child is significant on the security issue. Is it just that the child is more vulnerable, or are you making some argument based on risk of reoffense?
So my argument primarily is that it is an aggravating factor. It's a factor that's aggravating, that's been recognized by not only the legislature in sort of mandating a mandatory sentence for such offenses, but also really about the seriousness of the offense when you're factoring in the danger factor. And then also the SJC also recognizing it as an offense that is also violent to children and dangerous as well, and inherently violent. So that is sort of my suggestion in that regard, Your Honor. I apologize. I'm also working off of a computer screen here, so I just apologize. So that's my argument, as I indicated in my response, that the actions in this case, the very nature of the offenses being aggravated by the adult authority figure over the young vulnerable child, is certainly a demonstration that he presents a safety risk, not only to the child victim, but also to the general public at large. And then also, I do note that with respect to security concerns, the fact that he's only served a little over 2 years of his 10-year sentence, so that he has 8 years remaining, and then also followed by 5 years probation on the indecent conviction, so that if he violates probation, he has substantial and additional time beyond the 8 years that he still has remaining. So certainly for security purposes, I would suggest to Your Honor that he is a security risk based on that fact. And certainly the defendant would, if released, have an incentive post-conviction to flee. So I'd ask Your Honor to consider that fact when you're considering security.
But could the flight risks be mitigated through conditions of release, be it bail or GPS or something else?
I mean, that's always certainly a consideration in any case, but particularly in a case, it may be more suitable for an individual that doesn't have so much of a sentence remaining and additional and substantial time hanging over his head. Might be more suitable. But in this particular case, the stakes are extremely high with the fact pattern such as this one, in addition to the remaining balance of his sentence, in addition to the amount of substantial time hanging over his head, I would suggest to Your Honor. And then
why didn't he have, I mean, pre-trial, he still had substantial potential time hanging over his head. What changed other than the specific sentence here?
So I think, and we argue this a lot below, Your Honor, but I think the difference is that the defendant is convicted. So we're talking post-conviction. And so there is, although there is, sort of still that risk pre-trial, I think that the stakes are even higher post-conviction when a jury has already spoken and founded and have founded the defendant guilty of such violent crimes. So that, Your Honor, is I would think a substantial difference when you're considering sort of the distinction between pre-trial and post-conviction.
Okay, we're going to hear from Mr. Campbell now, but as I indicated earlier, I'm happy to give you some rebuttal time after he is done and vice versa. Mr. Campbell, why don't you start with answering the $64,000 question of whether your client was offered and received the vaccine?
Good afternoon. Alan Campbell for the defendant, Jose Rivera. And the answer to that $64,000 question is that he has received his first round of vaccination. I believe it was the Moderna vaccination. I'm not certain exactly when it was. I think Mr. Rivera said it was about 2 or 3 weeks ago, which puts it in the range of either of the dates that the Commonwealth mentioned earlier. But he's only had the one vaccination. I think it actually makes sense for me to, and obviously if you want to hear specifically about some things, but I think it makes sense for me just to run through from the beginning. I'm not going to spend any time on the first prong, because I think it's already been decided, and Your Honor has indicated that you agree with Judge Wentland. So then the next prong is a security prong, because as you know, because of NASH, it's clear we don't necessarily even need to reach the COVID factor. It's if he passes the first 2 tests, then he should be released. And I personally think he does meet those tests. There is nothing specific in the denial, the previous denials. There is nothing specific to Mr. Rivera. It's simply he's been convicted of a violent crime, serious and violent crime. So he's a security risk. And if that was the end of the inquiry, then the rules or the statute would say if you're convicted of child rape that you're not eligible for a stay, and they don't. So the powers that be have indicated he's eligible even though he's committed this crime. Not to minimize the crime, it is a serious crime. However, he wasn't convicted of statutory rape with force. He was convicted simply of statutory rape. So the jury didn't find that he imposed himself in a violent way on the teenager. They just found that he had sexual relations with her, which is enough. So again, I don't want to minimize it. It is a serious crime, but it's not like he grabbed somebody off the street, beat her up, and raped her. According to the testimony, they were sitting downstairs at a terrible time in Mr. Rivera's life. He said something crude to the effect of, let's go in the other room and do something. They did. He didn't drag her in. Again, I'm not minimizing. I'm sure it was a terrible experience for the complainant, but to suggest that he's going to be grabbing people off the street or doing other things, that's just not who this individual is. He has no prior record of criminal convictions. He was out on bail almost the entire time. I believe he was in for a month or 2 before he was able to make bail, and then he was out from that time throughout the pretrial proceedings. And at that point, he was facing potentially life sentence times 3. He had 3 life felonies plus an indecent A and B. And the court thought that he was not a safety risk at that point and allowed him to be out. He complied perfectly with his terms of release. There's no hint that he did anything, stepped even a toe out of line. Now he has been convicted. That certainly puts him in a slightly different light, but he received the absolute minimum sentence. He could have had 3 life sentences consecutive, and he received 10 years to 10 years and a day on each of them to be run concurrent.
I want to stop you there and make sure I understood what you just said. The minimum sentence for aggravated rape is 10 years?
Right, for statutory rape of a child aggravated by age difference, not by force, by age difference is 10 years. So he received the absolute minimum sentence, and then with a slight period of probation afterwards. And I should put out, just so in case Your Honor is considered referring to Justice O'Shea, he made an error of law at the hearing. I actually wasn't able to represent Mr. Rivera at that hearing, so that hearing was handled by his trial attorney. However, thanks to Court FM, I have been able to listen to the hearing. And
No, are you referring to the original motion for a stay hearing or the renewed motion?
The renewed motion. I represented him at the original motion. At the renewed motion, for whatever reason, Judge O'Shea insisted that it be an in-person hearing, and I was unable to attend the court on those days. So that was covered by his trial attorney. And as through Court FM, I've been able to listen to the proceedings. And twice during that hearing, and I put this in my affidavit, Judge O'Shea says, oh, well, he's got straight probation. It's a life felony. So theoretically, he's looking at, he could get a life sentence if he violates probation, which that's simply not the case. The probation is on the indecent A and B, which doesn't have a life sentence as the maximum. So it's just, again, as a matter of law, the judge was under, he had the facts wrong, or the legal exposure was wrong.
Well, what about the initial decision on the stay by the trial judge?
At the initial hearing, I don't believe the judge spoke about what his exposure was specifically on if he were to violate the probation.
No, but I refresh my recollection. Were there written findings the first time around, as opposed to the check the box?
It's just a check the box both times. And I think he may have added a sentence, due to the nature of the crimes, he's a flight risk. There was nothing specific to Mr. Rivera, again, who has no prior convictions, who was out pre-trial. It didn't violate or step a toe out of line. So it's no decision has tied the security risk to Mr. Rivera. It was simply the nature of the offense. And as we know from Nash, even if it's a crime that is abhorrent, you still need to tie it specifically to the defendant. It's not these crimes don't get stays. These ones, you have to look at the defendant. For all of them, you have to look at the defendant. And I would say that no judge who's looked at this case yet has done so, or at least they haven't put it in writing why specifically this defendant would be at risk. And also,
Counsel, just before you move on, how do you address your sister's argument that in Nash, it was not a child victim, apparently, it was an adult victim?
I do not believe that matters, because in Nash, it was indecent assault and battery, I believe, as well, which has an element of offensive or non-consensual touching, which again, in this case, it's a statutory rape. The jury didn't find that they didn't find that it was non-consensual. They didn't find that it was a forceful rape. They just found that he had sexual relations with a person that was underage. Again, not to minimize it, but it's not, the jury didn't find any violence other than the indecent A and B, for which he had straight probation. So on that offense, which has, one could argue that given that you'd have to find the act that it was a non-consensual or offensive touching, in that sense, that offense was actually the most violent of the offenses. And for that one, most likely he's not going to spend a single day in prison, because given who Mr. Rivera is based on his record, and this isn't a teenager saying, I don't have a record, it's a man in his 40s who doesn't have a prior record of convictions, he's not going to violate probation. It simply isn't. And if he does, he'll get sentenced and he'll show up. So sorry, I just lost my train of thought for a second there. And then one thing that Commonwealth didn't address, and I have a little more information on the plan. Perhaps I should have written that up yesterday and submitted an affidavit. I didn't have time to. I'm certainly willing to if the court isn't willing to just take my representations. The plan would be to stay with his brother who lives in Lawrence. And again, I apologize for my mistake. I had it right in my affidavit, but in the motion I put Lowell. His brother lives, it's a large home that's broken up into 6 units. He's the only person that lives in that unit. There's space for Mr. Rivera to live with him. There is, I also understand, and this is a few ifs, but if Mr. Rivera is let out and if he is able, with terms that allow him to work, He has a couple potential jobs lined up, and those would support him getting his own unit in that same residence. His brother wears a mask and does social distancing. His brother works for, I believe it's called Unitech, which is an industrial or a warehouse laundromat that does hospital uniforms and sheets, things of that nature. Wearing masks is mandatory at that job, and people social distance to the extent possible. That's one of the two jobs that Mr. Rivera could obtain if he's released. I understand from speaking with Mr. Rivera's brother that they are in need of people and having a tough time hiring people. So he would have no difficulty, should have no difficulty getting a job. It's also in Lawrence, a short distance. I'm not certain exactly how far from the residence, but he could go back and forth to work with his brother. The bubble would be, him and his brother. And again, the workplace does require masks and does social distancing. Another job that Mr. Rivera potentially has would be working for U-Haul in Boston. This was the job that he did while he was out pre-trial. That one would not be as an attractive as the working in Unitech, because that would require him to go into Boston. And his job there, although I wasn't able to speak with the employer as to their social distancing practices or wearing a mask, but his job would be, it's at a U-Haul, it would be cleaning out the trucks in between rentals. Having seen that done when I've read
Counsel, I'm just gonna stop you on this point, because I don't think that most of this stuff is actually in the record. And
yeah, that's fair.
I'm not sure this is going to turn on the specific employment opportunities.
Okay. Well, just to reiterate that he has some opportunities, and that is in an affidavit.
I take it you have discussed with your client the problem that even if he satisfies prong 1 of the Nash test at this time, that does not mean he's going to prevail in his appeal, and therefore he may, if he were released, he may find himself in a position where he has to go back in with an extended deadline in terms of when he can get out.
Obviously, we're hopeful that we will prevail on the appeal, but he understands and fully accepts that if we are not successful on the appeal, he will have a report date and he will be required to show up and serve the rest of his sentence. I don't want to be glib and say he's happy with that, but he accepts that. He's told me that's what he would do. I mean, the other alternative, if he doesn't, is he has to leave the area where he has spent his whole life, where his family is, or not his whole life, he's lived some other places briefly, but this is where his family is. His mother and stepdaughter in the area, his brother, and he has other family in the area, and then he would be on the run for the rest of his life. This is a 40-something-year-old man who has no prior record of convictions. To assume that he's going to decide to have a life on the lam during a global pandemic really does not make sense.
Now, same question I asked Ms. Nguyen. What's your reaction to the possibility of ways to mitigate any flight risk issues, be it bail or GPS or some similar?
I think I might think they're more effective than the Commonwealth does. Mr. Rivera is willing to comport with any restrictions that the court wishes to impose on him. If you would like to put a bracelet on him, give him a curfew, even frankly, be on house arrest. He would rather be spending the time in a space where he can be safe from COVID than in a dorm with 30 or 40 other people. We don't know exactly how many of them have been vaccinated, but if we assume the aggregate number, or take the aggregate number and apply it, that's a third of the inmates that he can't distance from haven't taken the vaccine. And the other number that's perhaps even more troubling is that over half of the staff that have been offered vaccines have refused. So even if all of the inmates are vaccinated, they're still exposed to a huge number of people coming in every day that aren't vaccinated and frankly aren't going to get vaccinated. If Your Honor looks online for stories about it, the guards apparently think it might make you sterile. So these people aren't going to get vaccinated. The ones that have already said no, they're not going to suddenly switch their mind. And even though he's been vaccinated, he's had the first round, it's not fully effective. Even after the second round, the second shot, it's not fully effective. It's a great thing. It should reduce it, and it would reduce probably him suffering serious consequences, but it doesn't mean he's not going to get COVID, and doesn't mean he's not going to have a chance still of having serious consequences. And what's more, there's no studies yet as to how well the Moderna vaccine, or frankly any of them, work against the UK or the South African variants, which, according to everything that I'm reading, will be the predominant variants within a month or two, even everywhere, but specifically here in Massachusetts in the prisons. So, and in the opposition, the Commonwealth goes on at length about, and again, it's my problem or my fault probably for putting Lowell in the motion rather than sticking with the Lawrence that was in my affidavit, but they say how prevalent it is in the community. Comparing a community to a prison where you're locked in a cell with people, there really isn't any comparison. Again, if he's at home, he can stay at home. And if he's released, he can choose to not approach people. He's not going to have 30 other people stuffed into the room with him, some of whom are going to be vaccinated, some who are not, some who wear their masks, some who wear, I've done some video calls, even if they're wearing a mask, sometimes it's wearing it down below the chin. So it's not like it's a hospital setting where they're all wearing their N95 masks and face shields and other stuff. You just simply can't get the same degree of safety in prison. And that's one of the things Nash says. The quote, everyone in a prison setting is at an increased risk. Mr. Rivera bears no burden on this third prong of COVID, and even a pure absence, which we didn't know was his motion was originally heard. Even if there's not a single case at Gardner, that doesn't mean that that third factor is decided against him, because he's in prison and it could show up like it did show up. And it just runs rampant through the system because prisons are not designed to deal with pandemics. And Your Honor mentions, I don't know how much faith we can have in these numbers that are kind of chunky. I would say you can't have any faith in them. The Commonwealth cites and looks at, we've only had positives on these dates or these dates. There's been no positive since the 11th or something, I think she said. Well, if you look at page 5, the last column, the reason there are no positives is there are no tests. And the number about the active cases, you can have absolutely zero confidence in that, because I believe it's 10 days after the positive test, the inmate is declared no longer active and is returned to population. They don't retest them. So when they're tested positive, they're listed as an active case. I believe 10 days later, not an active case.
Where do you get that from?
Where do I get that from?
The 10-day, you're automatically no longer active.
I believe I saw it in an affidavit in one of these cases, but one thing you can do is you can look at the number of active cases, which unfortunately the way this spreadsheet works, you have to look at different pages. But if you take the numbers on page 10, you see the active numbers are changing sometimes. And then you go up to page 4 or page 5, the last column on the right, you see there are no tests run on that day. So magically people are going from active to non-active. The only explanation can be it's a factor of time, because there were no negative tests that correspond with the active cases, if I'm being clear on that. These numbers, I mean, I don't want to say they're disingenuous. I'm sure the DOC is doing the best they can, but the numbers, they were told to give certain numbers and they're giving those numbers, but they're not actually giving an explanation of 10 people came off of whatever, off of the active list. We tested them, they're negative. That, you'll never see that because it hasn't happened.
Counsel, I'm going to give you an opportunity at the end to say whatever it is you feel you haven't been able to say, but I'm going to give the Commonwealth a chance to respond right now.
Thank you, Your Honor. There are two issues that I just wanted to address. First being, as I had indicated previously, the second round of the vaccination is scheduled at NCCI Gardner for today and tomorrow this week. So it's my understanding that the defendant will receive his second round either today or tomorrow. Secondly, to address the danger issue. Not to belabor the point too much, but I do want to suggest to Your Honor that the trial court, Judge O'Shea, the trial judge was the same judge that ruled on both the original motion for a stay as well as the renewed motion. I have before me his findings, which is that form. It was the form utilized in both of his rulings. But in particular, in the first instance, he had checked off that the defendant does present a risk of flight and potential danger to others. And then he did include a further explanation, and it does read as follows. Although Mr. Rivera has no default record in this case, his conviction for 3 counts of aggravated rape and 1 count of indecent assault and battery on a child under 14 years poses a substantial risk of flight. With respect to the most recent hearing below in the trial court with respect to the renewed motion and counsel's listening of the proceedings, which had indicated, as he asserts in his pleadings before Your Honor, an error with respect to the potential penalty that the defendant faces on the indecent assault and battery charge if he violates his conditions of probation. I do know, and I don't have a case at my fingertips, but I know there is case law out there that does indicate that ruminations from the bench are not binding. So what is binding is the final decision. But I think more importantly, I think that regardless if we're talking about a life penalty or a substantial penalty such as 20 years in addition to his remaining 8 years, we're talking about a substantial amount of time that the defendant is facing. So I think the principle is the same in both instances. So I think that that's what is key here when you're talking about his security risk. So certainly if he faces another life sentence, that is more substantial, but also facing an additional 20 years on top of his 8 years for an individual who I believe is 41 or 42 years old is substantial when you're factoring in the security risk that he poses.
Counsel, how do you address the fact that, at least in the second ruling, that is the denial of the renewed motion for a stay, the judge did not even bother to check any box on factor 3? So we don't even know that he faced the COVID factors.
So I don't actually have unfortunately, I don't have a copy of the most recent one before me about him not checking that. But if that is the case, he did hear the parties with respect to the COVID related concerns. I was actually present on behalf of the Commonwealth for that particular hearing, and arguments were heard. And they're also briefed by both attorneys. So I do think that was a consideration by the judge. Not sure why that box wasn't checked, but in any event, I do think it was considered. But it's also, I think, going to the point in Nash where, so putting aside the first prong, that the second prong is pretty substantial. I mean, at least prior to COVID, the pandemic, that factor alone was sufficient for a denial of a motion to stay. So I think that I do acknowledge, as counsel has done, that the second factor is significant in that respect, because even that alone, prior to the pandemic, would have been sufficient. So well, I do want to.
I think, counsel, that's an accurate statement of people's understanding of the law, but didn't Nash somewhat upend that? Because at least with regard to the Nash half of Nash, the court made it clear that it was resting on the first 2 factors alone. And despite the heinous nature of the crime, even though it didn't involve a child, the court said that's not enough on the security issues. And we don't even need to get to the COVID. So regardless of whether or not your understanding of the law pre-Nash is accurate, post-Nash, one could argue it's a whole new ballgame.
So, and I hope this answers your question, but
It was more of a comment, but go ahead.
but in that regard, I did want to actually comment a little bit more on the danger factor, because I know counsel was trying not to minimize the offenses, but unfortunately, and I don't want to belabor the point, but unfortunately, I do think it was minimized. He's trying to make a distinction between statutory rape and forcible rape. In this case, by the jury's verdict, they credited the victim, and the victim did testify that, when you're dealing with an authority figure, someone that she considered her dad, like a dad, after the first instance of vaginal rape, she testified she was hurt. She said, it hurt, and I was just like scared inside, because like I was really close with him. So I was just scared. And then she had indicated that she felt gross after the situation. After the second incident, which was months later, it was the first time that the victim had actually encountered the defendant after the first incident in November. So the first incident was in November, on November 19th, and the second incident of rape was on April 1st. So that was the second instance she had seen him after that incident. She did not want to go to his house thereafter. She was very close friends with the defendant's stepdaughter, and that was the reason that the defendant had access to the victim, was because of the friendship that his stepdaughter had with the victim. And he was also the godfather as well to this victim. But after that second instance, which was where he forced her to put his penis in her mouth and then he vaginally raped her, she testified that as follows. She had, after the incident, she went to the couch and she testified she was thinking. And when asked what she was thinking, the victim testified about what just happened again. I didn't think it was going to happen again, to be honest. I don't know. It was gross. I don't know. When asked how she felt about what had just happened, she had testified, I was hurt. And there was also testimony with regard to as follows. We were close, really close. Like I could trust him with anything. Like we were really close. He could trust me with anything. Like we talked to each other about everything. And when asked, how did you think of him? She testified, as like another father figure. I mean, I do have a dad, but like he was like really close. That was her testimony. So I think that, and I know I argued this previously, but I do think the fact that we are dealing with this relationship, whether it was an authority, that he was an authority figure over this young child, 13, and he played a father figure role, and that he took advantage of that role. I think that is significant and cannot be minimized. And although the conviction was for an aggravated rape of a child due to the age difference, I don't think that could be minimized as saying the jury didn't find force. This isn't a situation where the defendant picked some stranger off the street and sexually assaulted that stranger. No, this is even worse because we're dealing with a situation where someone held an authority figure over a child and then violated that child's trust. So to me, that is very significant when you're dealing with when you're considering the serious nature of the charges and factoring that into the danger to the community and the victim.
Counsel, I certainly understand and appreciate the argument. Doesn't the stranger context, though, if Sorba were here, they'd say that increases the pool of victims and therefore increases the risk of reoffense. It's especially in intrafamilial situations. This isn't quite intrafamilial, but it's close. The actual risk of reoffense is considered less than it is where there's a much larger pool of potential victims.
That's very interesting. I think that you can also counter that. I think these are both great discussions. I think you can also counter that with the fact that there's an individual here that specifically targeted someone he was close to. in his home. So they didn't live in the same home, but he specifically targeted a child that simply was vulnerable. So I think that the fact that someone would, in fact, violate someone where there was a trust relationship, you could also argue that that also poses a risk that he would reoffend with another individual that held trust in him and also viewed him as an authority figure. So I think that you can make the argument with respect to both scenarios, sort of a stranger date rape scenario and also an authority figure with a close relationship.
Okay, counsel, I think I understand your argument. So unless you have something new, I think I will turn it back for one last round with Attorney Campbell.
Thank you. Those are the two issues I wanted to address. Thank you.
Thank you, counsel.
Just briefly, before NASH and before COVID, there were two factors that had to be considered. After COVID and NASH and Christie, there are now three factors. There's no additional burden on the defendant. It's not like you still have to meet exactly those two and then address a third one. It's, and I'm not exactly certain, but you meet the first one. Under the second one, before COVID, maybe I wouldn't have released them, but now you have to, and I don't want to call it a safety valve, or maybe I do because it relates to the defendant's safety. But now you have the safety valve of the third factor where you have to not only consider the risks to everyone else if he's released, but you have to look at the risks to him if he stays in. That's meaningless if he still has to meet the security one the same way before. So unless the SJC is wasting a lot of ink and a lot of lawyers are wasting time, this third factor in some ways replaces the second one or modifies the second prong. So it has to be that the security concerns necessary to justify releasing him are lower if you have a risk of COVID. He has a risk of COVID. So it has to be a lesser security risk. And just a blanket, this is a horrible crime, he's a security risk, that can't be enough, especially where he's at risk of being vaccinated. And I heard COMMONWEALTH say that he's probably likely scheduled to get his second shot here today or tomorrow. I hope he does. As I mentioned previously, that still doesn't get him out of the water, doesn't make him fully safe. He would be much safer even if he's on house arrest at his brother's apartment in Lawrence. And if you think that there's some risk to children, which I say this is an aberration, it's a two-time thing based on a terrible time in his life with his wife having just died. Not to explain it, but just to give some context. Add a condition that he's not to have contact with minor children. If he does, he'll get violated and he'll be right back in. And it might even, that actually, I don't know the legality of it, but if he were to violate that term of probation, that might be enough to violate him on this straight probation that he's sentenced to. So he's not going to do that. He's not an idiot. He's a 40-something-year-old man. He's owned his own house. He's worked. He has, again, no prior convictions in his record. He was out for a substantial period of time when he was facing multiple life felonies. He followed the directions of the probation department to the T. He showed up. When he was convicted, he didn't try and bolt from the courtroom. And at that point, when he's convicted, he certainly could have, because he could have been sentenced to life. He didn't. He stayed, he was sentenced, he received the absolute minimum sentence he possibly could on the three charges. And that should speak volumes. The Commonwealth had asked for much greater time. I think they asked for 15 to 20 years, and he got the absolute minimum. So at sentencing, the court recognized that Mr. Rivera doesn't have a history of these sort of offenses. He's likely never to do something like this again. Hopefully this is his only time going through the criminal system. And hopefully he gets released on a stay. He doesn't die from COVID, he wins his appeal, and he can always life. But unless there are any other specific questions.
I think I get it. So I will take the matter under advisement. I don't tend to let these things sit, so you can expect a ruling tomorrow or Monday. And I appreciate both of your assistance and candor. So thank you very much.
Thank you, Your Honor.